20th, 2017, the Utah Court of Appeals issued its decision in the case of In Re S.K.A. The link to the court's full decision is provided in this link, and we also include the link in the description section of this video report. In April of 2015, when a child known by the initials S.K.A. was 17 years old, the state filed a delinquency petition in the juvenile court alleging that S.K.A. had committed assault, an offense that would be a Class B misdemeanor if committed by an adult. S.K.A. was ultimately sentenced after S.K.A. had turned 18. He appeals the juvenile court's dispositional order, which included suspended jail time. The Court of Appeals affirmed the orders of the juvenile court. The juvenile court ultimately released S.K.A. from DCFS custody, converted S.K.A.'s 99 remaining community service hours into a $495 fine, fined S.K.A. an additional $325 for the assault, and sentenced S.K.A. to 10 days in the Salt Lake County Jail, suspended upon compliance with court orders. S.K.A. appealed, contending that the juvenile court erred in concluding that the Salt Lake County Jail constitutes a, quote, alternative to detention, close quote, under Utah Code Section 78A-6-117 sub 2F. The question whether adult jail constitutes either, quote, a place of detention or an alternative to detention, close quote, is the question the Court of Appeals addressed, and they concluded that they resolved it in the case of In Re O.P., that under the relevant statutory provisions, an adult jail cannot be considered, quote, a place of detention, but is, quote, a permissible alternative to detention because jail cannot be considered a place of detention under 78A-6-117, and thus it follows that jail is something different from a place of detention. Or, at least according to the ordinary usage of the term alternative, it is an alternative to detention. Although a juvenile court's authority to commit a minor to an alternative to detention is not unlimited, the legislature has conferred on juvenile courts the authority to confine a minor to jail in certain circumstances. The only remaining question is whether, under the specific circumstances of S.K.A.'s case, the juvenile court acted within its authority when it sentenced S.K.A. to suspended jail time. The juvenile court stated that it was, quote, going to order 10 days in the Salt Lake County Jail, which are suspended, close quote. The court told S.K.A., quote, I am not sending you to jail today, but if you violate the court order by not getting your fines and fees paid at that time, you could be going to jail, close quote. Although not explicit, the juvenile court's imposition of suspended jail time appears to have been an effort to encourage S.K.A. to timely pay his fines, which the court had imposed in lieu of requiring S.K.A. to complete his remaining community service hours. Put differently, the court's order was an apparent attempt to hold S.K.A. individually accountable for his actions. Because this motivation is consistent with the purposes of the juvenile court, the Court of Appeals could not conclude that the juvenile court committed error by sentencing S.K.A. to a suspended jail term as an alternative to detention. Even though S.K.A. was still a child at the time of his offense, he was an adult at the time of sentencing. While the Utah Code prevents a child in this situation from being committed to jail, child means a person under 18 years of age. S.K.A. acknowledged that subsection 78A-6-117(2)T, quote, only forbids the imposition of jail for a child, and that he was no longer a child under the statutory definition by the time his case was adjudicated. Thus, the order of the juvenile court was affirmed.